married in Canada. When they're in California, they will be recognized as legally married.
Right, but they still have the same thing, that the marriages after November 8th will not be recognized.
That's correct. That's correct.
All right. So what is the significance of the single economic unit concept for married couples and the 1930 Supreme Court decision, Poe versus Seaborn?
Well, this is about how the tax law ought to view a married couple. Are they one taxpayer or two taxpayers? For income tax purposes, originally, they were always considered two individual taxpayers. For estate and gift tax purposes, transfers from a husband to a wife would be a transfer from one taxpayer to another, and could be reached by the gift tax. Mm-hmm. There was no marital deduction when the gift tax and the estate tax was first enacted. So when a husband, he was usually the one who owned the property in those days, when he either gave his wife property or he died and left property to her, those would be taxable transfers under gift and estate tax. But then along comes a case called Poe versus Seaborn, decided by the U.S. Supreme Court in 1930. It held that under community property law, that was Washington community property law, but eventually every community property state was treated the same. Under community property law, since the state law makes all community property owned equally, the fact that the wife ended up with half of the husband's earnings was not a taxable transfer for gift tax purposes. And of course, at death, the first spouse to die, only half of the marital estate would be included in his taxable estate, whereas in non-community property states, if the husband had accumulated all the wealth and it was in his name and he died first, 100% of the property that was acquired during marriage would be taxed. A lot of people in New York and Florida thought that was unfair.
Yeah, you get a big tax bill.
They get a big one, yes. But Congress eventually did, well, it did something to clarify that. Okay. When it enacted joint returns in 1948 to take care of the income tax problem, it also enacted a marital deduction. For the first time, there was a 50% marital deduction. It was thought that that would effectively split the marital estate in non-community property states the way the community property law had already split it for community property spouses.
Right, and then eventually, of course, we got an unlimited.
And then, now we really do have the single economic unit concept, because in 1981, Congress went further and gave an unlimited marital deduction. So for married couples who are combining their wealth together, transfers between them do not trigger any gift tax or any estate tax. It's an unlimited or 100% marital deduction. Now, you have to give it to your spouse to get the marital deduction. I like to remind people of that.
Yeah, right.
But once you do, there are no transfers. So they really, husband and wife, for gift and estate tax purposes, really are treated as a single economic unit now.
Okay, good. Now, if I support my same-sex spouse or a registered domestic partner, is that a taxable gift?
Well, that's an interesting question. I think not, but let's start with one principle that I think a lot of people are not aware of. If you support a spouse or a minor child, someone that under state law you are required to support, transfers in satisfaction of that support obligation have never been treated as taxable gifts. So back even when husband and wife were taxed on gifts made between them, to the extent they were paying for support for the other spouse, that was never a taxable gift. But when I support my mother, who doesn't have enough money to support herself, when I chip in and support her, if I offer more than $13,000 per year for her support, $13,000 is the annual exclusion from gift tax. The first dollar of a $13,000 is a taxable gift. A lot of people don't understand that, because I may feel morally obligated to support my mother, but I'm not legally obligated. So when you support family members other than spouses or children whom you're legally obligated to support, you may be making taxable gifts if the support is more than $13,000 a year. In California, since we're in a recognition state, if you are supporting your cohabitant, your partner, you ought to consider entering into a registered domestic partnership, because under the registered domestic partnership law, you are required by the state to support your partner. So any fulfillment of that obligation would not be a taxable gift. We don't have any ruling from the IRS that says that, but that's perfectly consistent with all of the rules they've ever issued on this topic.
Yeah, it's very tough right now. I mean, there's the things that would say this makes sense, and unfortunately, some of the positions that the IRS has taken haven't necessarily made sense. So we'll be moving, I think, into that a little bit more later. Okay.
Well, I should probably mention the one position that the IRS has taken.
Yes.
They've ruled nothing about community property and registered domestic partners or same-sex spouses, other than the issuance of the informal advisory memo, a chief counsel advisory in 2006 that said, for income tax purposes, and only for purposes of whether or who gets taxed on the earned income of one of the partners, we will tax the earner rather than recognizing community property. So this has led a number of practitioners, family law practitioners, estate planners as well, to question whether that's a signal that the IRS is really not going to recognize the community property rights at all.
Yes.
So that when my partner spends her 50% of the community property that is attributable to my earnings, when she actually uses it to buy something for herself, have I made a taxable gift at that time?
Yeah.
Or when a relationship is dissolved and each partner walks away with 50% of the community property, is that a taxable gift? It would be nice to have some guidance from the IRS. I think the community property regime is so clear and so entrenched, and it clearly applies to registered domestic partners. And under case law, if I am immediately vested with my 50% interest in community property the moment it comes into existence, there's no transfer.
Yeah.
There's no transfer between spouses. There's no transfer between, and without a transfer, you can't have a gift tax.
Right. So this is what's important to understand here is that we view community property, or it's not just we view, it is. It is a property right. It is a California property right. And we have this old case, this Poe versus Seaborn, and it says those property rights should be respected for tax purposes.
Yes. Now, the problem is when compared to other states that don't recognize community property. You can own property jointly in other states.
Yes.
And same-sex couples often do. They will own property as joint tenants with right of survivorship, or they will own property as tenants in common. And the IRS will recognize that joint ownership. They have to. It's the state property law. But if one partner contributes 100% of the purchase price and then puts both partners on the title, there's a taxable gift as to 50% of the interest. Whereas I'm arguing that under community property law, even if I pay 100% of the purchase price for our home, let's say, and it's vested in us as community property because it's paid with community earnings, I haven't really transferred anything to my partner. The state has.
Yes.
And so it is not a taxable gift.
Okay. So this sort of dovetails with that then. What if I own the home? I guess we're saying, what if I own the home before we become registered domestic partners or get married and we're same-sex couple? In a sense, though, we could say this applies also for the unmarried couples. In this particular case, we said that that would apply. So I transfer 50% interest to my partner.
That's a taxable gift. Yeah. If it's not community property, which it would not be if you owned it prior to registration or marriage, a lot of people think they're putting the partner on the deed just for protection or to get the survivorship feature, and they don't really feel like they've transferred an interest away. But even if what you've created is a joint tenancy with right of survivorship, that joint tenancy under property law can be severed by the other partner. She can walk away with a 50% interest in the property. So it's vested the minute that you put that person on the deed and deliver the deed.
Yeah. So
and that makes a taxable gift.
So don't think of joint tenancy for convenience.
No.
You know, and I have a lot
don't
of
start conveying property interests to your partner without consulting a tax lawyer.
And again, if for federal purposes, at least right now, there is an unlimited marital deduction for conventional married couples.
Exactly.
But that does not apply for any of those other circumstances.
So long as DOMA is on the books, it won't apply to same-sex couples, right?